Okay. Ready, Jim? Oh, thanks. Good morning. Welcome. Today we'll hear oral arguments in the matter of Arizona Electric Power Company Cooperative versus BNSF and Union Pacific, STB docket number 42113. In an effort to move things along, the board members will not be making opening remarks this morning, but I wanted to cover a few procedural matters before we begin. We have asked each party to make a short statement of their arguments, but counsel should be prepared to answer questions from the board at any time during your allotted time. Counsel for complainant has been allotted 30 minutes total and has requested to open with 25 minutes and reserve 5 minutes for rebuttal. Counsel for defendant, BNSF, and Union Pacific have been allotted a total of 30 minutes and have agreed to allocate this time between the two. Speakers, please note that the timing lights are in front of me. You will see a yellow light when you have 1 minute remaining and a red light when your time has expired. The yellow 1 minute light will be accompanied by a single chime, and the red light signifying that your time has expired will be accompanied by 2 chimes. Please keep to the time you've been allotted. When you see the red light and hear the double chime, please finish your thought and take a seat. Counsel for BNSF and Union Pacific, please inform the board before you begin your presentations the amount of time you have opted for as between the two of you so that we may set the timer accordingly. Additionally, just a reminder to everyone here, please turn off your cell phones. Counsel for EPCO, you may now begin. As noted, you have requested 25 minutes and 5 for an opening and 5 for rebuttal. Please step up to the podium, introduce yourself for the record, and begin. I did want to, before you get started, one of the issues that I thought was really important when I was looking through the briefs was the recession issue and how that's dealt with. You know, I noticed that you had used certain numbers and that defendants had used different numbers, and then didn't seem like any of the current numbers where the traffic has spiked back up had been used. And I was just curious also to hear how you guys thought we should address that in this proceeding. That to me was one of the most important issues that I was looking at going through. Thanks.
Thank you. Good morning. I am Robert Rosenberg of Slover and Loftus, appearing on behalf of the complainant, Arizona Electric Power Cooperative, or APCO. Let me note that to my left is Skip Whitley, who is APCO's corporate counsel and is the APCO senior official that currently has direct responsibility for APCO's coal supply and coal transportation matters. By way of brief background, APCO is a relatively small, consumer-owned, nonprofit rural electric cooperative. It is directly responsible for supplying power to roughly 130,000 homes and businesses, primarily in rural Arizona. To serve those customers, APCO burns roughly 1.2 to 1.5 million tons of coal per year at its Apache generating station located near Cochise, Arizona. APCO is a classic captive shipper, as coal can be delivered to Apache only by Union Pacific. This rate case, APCO's third, marks the latest chapter in APCO's ongoing efforts to obtain reasonable rates for moving coal to Apache. Let me have projected on the screen a PowerPoint. There it is, and I've distributed copies as well in case the scale is too small on the screen. That's a schematic of APCO's standalone railroad, or SAR, which may make it easier to follow some of my comments. APCO based its approach in this rate case directly on the board's ruling in APCO's prior rate case, as well as other recent board orders. In particular, APCO constructs the Vaughan-El Paso segment and does not use the trackage rights approach disallowed in APCO's earlier rate case. Otherwise, APCO utilizes the SAC approach that it proposed and the board approved in APCO's prior rate case. That specifically includes routing the New Mexico traffic via Vaughan-El Paso and having the reasonableness of the PRB rates determined using a SAR that also handles the New Mexico rates. Neither aspect of APCO's presentation should be particularly exceptional. The coal rate guidelines specifically contemplate and authorize rerouting traffic over a longer route to achieve economies of density. That's what APCO has done here. To require the standalone railroad to replicate the incumbent's operations violates the least cost, most efficient essence of standalone costing. It also constitutes an impermissible entry barrier. Furthermore, Congress specified in the conference report to the Staggers Act that the rate standards for joint rates should be the same as for single-line rates.
Let me ask you one question. You're routing this traffic through Amarillo, which is pretty far to the east of existing lines. Is there any limit to how much you can reroute traffic to achieve your traffic densities or to achieve lower costs? I mean, could you run the thing to South Carolina, for example, and then run it back again? Would that be permissible theoretically?
Well, first, let me make clear that the New Mexico traffic does not go to Amarillo. It goes to Vaughn, then it heads
You are
south.
running PRB traffic down there.
Right, the PRB traffic does go. It's a modest extension. It reflects desirable densities, and there become I think practical limits, and also with limits with divisions, and it would add additional costs. So we think that this extension here is well within the realm of reasonableness, and I don't think the railroads have even attacked that element of the PRB routing.
Thank you.
Mr. Rosenberg, if I could just follow up on that point. What is it about Amarillo that is attractive from your perspective? Is it that it's also a major east-west intermodal corridor, so you pick up a whole lot more density? Is that one of the features? What else can you tell us about the attractiveness of picking up Amarillo?
It reflects desirable densities. There are higher densities there than along the other routing, and it utilizes a higher denser network, so it reflects least cost, most efficient principles as contemplated in the coal rate guidelines.
Can you imagine a case where coal traffic is interposed with along a very congested primarily intermodal corridor, which to such an extent that would require the railroad involved to actually build out new capacity to accommodate the proposed coal traffic? Having a high-density coal corridor and a high-density intermodal corridor on limited track capacity obviously could result in some situations in build-out and expansion requirements. How would those type of considerations, how should they be factored in to the economic analysis of a case like this?
Well, the shipper is effectively required to conduct a simulation of the operation of the railroad using the RTC program. If the RTC program shows that the standalone railroad doesn't provide reasonably equivalent service, then you need to start adding additional facilities in order for the service to be equivalent, or you look at a different configuration. We submitted an RTC simulation here, and it shows that our performance is at least as good and in most respects better than the incumbents. It's also the case here, and typically that there's some traffic that the incumbents have that the standalone railroad or the shipper decides not to handle, and that's taken into account in the analysis as well.
Thank you.
Continue where I think I was. The railroads are not allowed to split their joint through rate into two parts and require APCO to replicate each part separately instead of moving freight from the origins to the Apache destination in a least cost and most efficient manner without entry barriers. While the railroads claim that APCO's SAR involves some sort of impermissible cross-subsidy, they make no attempt to back up that claim with the PPL, Montana, or Ottertail type analysis, which is the board's specified standard for determining if a SAR has an impermissible cross-subsidy. Furthermore, about 2/3 of the SAR route miles that are used to handle the New Mexico traffic are also used to handle the PRB traffic. It is thus logical and efficient that the SAR facilities used to handle the New Mexico issue traffic are also used to handle the PRB issue traffic.
Quick question about the PRB traffic. Can the plant at issue burn the PRB coal? Are you aware?
Yes. Some years ago, and around the time of APCO's earlier rate case, APCO invested substantial sums in a coal blending facility at the plant that enables it to burn, a range of coals. And it has burned some PRB coal. It's burned Colorado coal. It's burned, it's burning primarily New Mexico coal now. The coals each have some desirable characteristics. They have some undesirable characteristics, particularly coal in certain cases. And the blending facility lets APCO mix those coals to achieve an efficient and effective blend.
Thank you.
Mr. Rosenberg, if I could follow up on that, where does your client get its coal currently, or where is it predominantly purchased or sourced its coal over recent years?
Well, it's been a mix since the most recent contract expired, and APCO's been looking at the railroad's rates, and because of other factors, they've been getting coal from New Mexico. Prior to that, under the contract, a good bit of the coal came from Colorado and also from the Powder River Basin, as well as in New Mexico. I think in years past they've taken coal even from Utah, I believe. So it's a function of the markets, and in large part the railroads are in a position to dictate where APCO's coal comes from. APCO needs a blend that will work in its plants, and then it wants the lowest delivered cost consistent with that, and the railroad prices are a major input into that.
When APCO requested a tariff rate for Powder River Basin coal that triggered this complaint, what kind of volume were we talking about, and what was the source? Was it a specific mine that was actually up and running and open, or was it a mine that might have capacity or in coal in the future? The record was a little bit confusing on those points.
Okay. But my recollection may be a little bit off, but I think there was initially a request for Decker and Spring Creek that are located in Montana, and I think also mines in what's called the northern Wyoming basin, the mines that are captive to BNSF. APCO also had a request for rates from the southern basin and also from Colorado, and that's tied up in the litigation in Tucson, and that's in the sub number 1 sub docket, so we're not able to prosecute a rate case as to those rates at this time. APCO also requested rates from the Signal Peak mine, which is located further north. That mine is coming online. It's having some issues getting up to full capacity, but that coal has coal characteristics that are very similar to the Colorado coal. We're also similar to the coal from McKinley Mine, which is located in New Mexico and had a higher BTU content and lower sulfur content and other desirable qualities. And APCO hasn't yet taken coal from that mine. Yeah, again, there's not a lot of coal that's available for third-party purchases, but there stands to be over time. The way APCO designed its standalone cost presentation, it doesn't build out to that mine to allow service to begin from there until 2012.
How does that work? You mentioned the Signal Peak mine is not online and is having some, quote, issues.
Well,
if I could just, we're trying to work here to resolve hopefully a very real and significant commercial dispute, and I'm worried that part of the dispute might involve something somewhat hypothetical. Not the SAR, that's fine, that's a hypothetical part of the case that's obviously built into our process, but a mine that's not actually ready to produce coal to be delivered, you request a rate for that. What if the railroad had said, we can't give you a rate until we learn more about the mine's operating availability and whether they're open for business? Would you still be here complaining about that rate? It sounds somewhat a little bit speculative to me. I know your client has to plan for the future. You can't just wait till you're a week away from running out of coal. You've got to be lining up new sources in the future. I understand that, but help me understand and get a little more comfortable with the signal peak situation?
Okay, well, it's not. I don't think the situation is nearly as speculative as your questions might indicate. The mine is up. The mine is operating. BNSF is hauling coal from that mine. It hasn't hit, I think, the 10 million tons a year that is what's projected. But a lot of money's been invested. The mine is operating. I think there is coal that's going to First Energy in Ohio. There was the big investor in the mine. We did request a rate. We did get a rate. We would be able to if we entered into a contract, we'd be able to ship it now. In part because the arrangements APCO entered into when the rate case was starting based upon the coal market conditions at this time, and some of this is frankly of a highly confidential nature, and I don't want to be disclosing all the details. It is explained in our evidence. APCO doesn't anticipate if things happen, if there are force majeure events, if production doesn't occur, APCO may take the coal before then, but it becomes there becomes more of a material need starting in 2012. And again, we do have the rate, and there is coal that's moving, that BNSF is handling, that moves from that mine to other destinations.
Okay, just to finish this line, I want to let you get back to your time. But what type of volumes are we talking about here? Did you order a carload or two for a test burn, or was this a request for unit train service of coal over a long period of time? I'm trying to understand the type of transaction we're talking about here.
Okay, APCO has had at least two train loads, I believe, from the Decker mine. Again, APCO has stockpiled until the time that it's from when this earlier contract was in effect, coal from McKinley and also coal from Colorado that is very useful to APCO operationally. So there have been train loads. There may be more before its current New Mexico contract runs out, depending on production, depending on burn levels and those factors.
So there have been two train loads delivered from the Decker mine?
I believe so, yes.
And any other train loads delivered under this tariff from the other Powder River Basin mines?
I don't believe so. I could be off by a train load or two, but I think that's correct.
Unit train loads? I mean, entire train?
Yes. It's a unit train that goes up there, it comes back, then it heads someplace else.
Thank you.
Commissioner Nottingham makes the point that the SAW, after all, is a hypothetical railroad. We deal in hypotheticals, but it strikes me that there's also some purpose or there should be some attempt that the railroad that you build, the SAW, should have some semblance to a real world operation. I have a question as to whether the SAW that's constructed, this SAW has 24 interchanges, and yet it doesn't have any switches built into it. It has a lot of characteristics where you would expect the SAW to be interchanging traffic with connecting carriers, but the assumption is that there really isn't, that it's basically a bridge carrier. How is this SAW, how are we supposed to look at the SAW that you've created and consider it a kind of a real world operation? I mean, you, for example, use the ERCS course of the defendant, which is based upon coal traffic, and yet your SAW will carry mostly intermodal traffic, unless I'm mistaken. So, could you reconcile your SAW with real world operations and why we should accept that SAW?
Well, the SAW reflects the facilities that APCO utilizes, and APCO is a unit train shipper. It also reflects other traffic grouped together, consistent with the coal rate guidelines. To serve APCO, you don't need to switch individual carloads. The segments that APCO utilizes handle a number of intact train loads, and APCO basically captures in its SAR the facilities that are needed to handle its traffic and other third-party traffic that is efficient and cost-effective. You mentioned the 24 interchanges. I think a number of those are probably the coal mines and not points where it interchanges with other carriers, but it does have the interchanges where it takes train loads intact and moves them on. That's the portion of the system that APCO utilizes to require the SAR to engage in individual train loads and other sorts of things, is to require APCO to have to cross-subsidize the defendant's other traffic. And the grouping principle is, the coal rate guidelines say that that's key to contestable markets, and that's what our railroad is built around. If you go down to say where the power plant is at Cochise, Arizona, and you look at UP's main line, you'll see all of these large trains moving past it and moving to or from El Paso, and then moving up to Vaughn. That's the traffic in the area. That's the traffic that APCO incorporates, and that's what the coal rate guidelines say to do. That's what contestable markets say to do. To require APCO to take on other things is to impose an entry barrier and to undermine the least cost, most efficient principle.
Thank you.
Would you mind, I know you've been peppered with questions since you've got out of the box, but I'm still very curious about how we're going to deal with the recession. And my understanding is that you received some data pre-recession, you've done your numbers, and then the railroad came along and made some adjustments for the recession. There's some arguments that there might have been some cherry picking, and then also there's another argument that the recent uptick in numbers haven't been addressed. And what I'm concerned about is, if we keep going along and along, that this case could drag out farther. And I was wondering, obviously the recession occurred. What's your idea of the best way to deal with those numbers, the uptick, and obviously the pre-recession positive, good numbers?
Okay, well, let me contrast what APCO did and with what the railroads did. What APCO did is, of necessity, we worked with the data and the forecast that the railroads provided, as well as other publicly available data. The last complete set of data that the railroads provided went through the first quarter of 2009. That's what we worked from in devising our traffic route. And then we used a combination of railroad forecasts and other public information to forecast what would happen. And that data shows a decline in 2Q through 4Q09, and we reflect that, and then we use the original forecast that we put together as adjusted for certain technical errors and certain additional information provided of a different sort. What the railroads purport to have done is to have selected their own traffic group, and including the earlier data, but also data from 2Q09 through 4Q09, which is more recent, except that they did not provide that data in a complete manner. They didn't put it in the record. So they put together a traffic group, but we frankly don't have the data to see what's in it and what's not in it. However, from what we can discern, it's incomplete. It was selected in a manner that truncated our traffic group selection. It doesn't take into account when to a full extent when traffic moves. It switches to move from a different origin to the same destination, or from the same origin to a different destination, or involves new origins or destinations. That's part of the flexibility that reflects the operation of the market, and their analysis truncates that. In other examples, they try to get something similar to our traffic group, but they say they take, in the case of the BNSF non-coal trains, they do it by the train symbols, but they include a train symbol only if 90% of a particular train symbol was included in APCO's traffic group. So, for example, if APCO included 89.6% of trains with a certain symbol, they discard those trains altogether. So they end up with a different traffic group. And again, they didn't produce the data, so we can't tell what's in it. Again, APCO went on a train-by-train basis, deciding which trains to include, which trains not to include. For example, if a train had an external reroute, APCO would exclude that train. Everything suggests that the railroads didn't engage in that process. They engaged in something more simple, more arbitrary, and that yields a more favorable answer to them. But even if they had done it properly, and again, our position is that they didn't, they simply took the favorable data that was available to them, in this case, data showing 2009 decreases, but they ignore more recent data and any of the Wall Street analysts are, present things showing the increase in double derivative, double-digit increases in traffic in 2010. So they engage in this selective updating, which is asymmetric and unfair. And our point is that if they took all of the evidence into account, it would show our initial forecast is reasonable and even conservative, particularly looking at how the railroads' volumes, their revenues, and profits are recovering.
A procedural question. You mentioned about the construction of your traffic group, and I gather that you were not happy with the discovery process, that you felt that BNSF or UP were too slow or didn't give you all the information you needed to build your traffic group. Is that correct? And if so, why didn't you petition the board for a motion to compel that they would give you the data if you thought that the responses were insufficient?
Okay, we got enough data to work from the 2Q08 through 1Q09 period. What our objection is, primarily in our evidence, is to the railroad's effort to rely on the 2Q through 4Q09 data that hadn't been provided to us previously, and they did not provide it in their work papers. As a consequence, we couldn't work from it. Frankly, if they had done it, then in order to select, to devise our traffic route, we would have had to have gone what we did with the initial evidence, which is to go train load by, we'd have to go car by car, train by train, and assemble a whole new traffic group. That would take a number of additional months. We couldn't have done it in the initial procedural schedule. It would have entailed enormous expense, and then after we did that, then the railroads would claim there was a new traffic group. They would want to put in some sort of rebuttal, and then we would have to respond to that. So we'd be in this perpetual game of catch up, and it would endanger our or the board's ability to comply with the 3-year deadline. I'll also say that the discovery never goes as smoothly and as quickly as a shipper would like in a rate case. But our objection here is to their selective use of data that was not even put into the record. But it's clear that they didn't use the sort of process that the shipper is required to utilize.
Thank you. Over the past 6 years, I've noticed that the discovery process doesn't always go smoothly. I want to point out that the members have had some questions prepared by staff. I have 7 pages of questions in front of me, and I'm just wondering if the chair would want to continue a little bit longer on this, because there is so much to ask.
Sure, I know. Commissioner Nottingham has questions also. So.
And Mr. Chairman, is it fair to say we'll have opportunities to ask questions as
he's going to come back on rebuttal.
Correct. Thank you. I'll just have one follow-up on that point. we obviously take very seriously here at the board any assertion that a party has withheld information during discovery. And I know I'm assuming we have many practitioners observing this proceeding, and I want to make sure they all know that if you're ever in a dispute pending before the STB and you think another party is not being forthcoming in discovery, what you do is you reach out to the board and file the appropriate motions to compel that information if you think it's actually important to your client. In this case, I'm hearing that maybe you felt it wasn't important because you already made up your mind that there was one time period you wanted to capture for your base period because perhaps it reflected a economic peak level of traffic, and no matter what the other parties or the defendants provided or didn't provide in the way of more recent data, that wasn't of use to you. And so I guess what I'm asking is, why are you complaining about that if you had no intention of using the contemporaneous, more recent data that the railroads, at least in part, provided?
I'd like to. I'm forced to take issue with your characterization. Once we finally had gotten a complete set of data that we could work with, that includes revenue tapes, it includes train movement, and it includes car data, and we need to take it apart and put it together and assemble. We had gotten the data through 1Q09. That gave us a complete set, and we started working with it. It takes a considerable period of time, and we put our evidence in, and I think it was I think January of 2009, and we worked as quickly as we could, putting the data together, also doing the RTC simulation. That was timely with what we had at the time. It had taken us a good bit of time to get the complete data that we had, and we worked from it, in a reasonable manner. We had complete data, and we were able to proceed with our case that had already been delayed. We're conscious of the 3-year limit. The recession did not start in 2009. It started in 2008, and we reflected that data. We relied on things that reflected it. We believed then, and we still believe now, that we have made an accurate estimate of the long-term trend.
Mr. Rosenberg, if I could, just thank you. I think you've responded. I just want to make sure I understand. Your client got all the data it needed to bring the case that you felt you wanted to bring. Is that correct?
We got enough data that we could work with comfortably, yes.
Okay. Because if you hadn't, of course, if your client was going to be disadvantaged, you would have obviously come to the board. You're no stranger to our processes. You would have come and asked for relief, correct?
Well, we try not to come to the board unnecessarily. We try to work with opposing counsel. Frankly, in most cases, we're able to compromise and work it out. We've both been through this a number of times. If we can come to a reasonable accommodation, we do so. The objection here is that they put in their reply evidence, and they don't provide the data to back it up. Plus, the analysis that they do does not comport with how a shipper would go about selecting its traffic route. It's defective data-wise. It's also defective analytically.
Do you think this purported lack of some data is important enough for the board to make sure that we take action to correct and fulfill and fill out the record, or is this a non-issue? I'm just trying to understand. You're sort of saying on the one hand it's a non-issue because you were able to bring the case you wanted to bring, but then you're saying on the other hand you're actually concerned that the defendants allegedly didn't provide all the information that you might have wished they had provided. Do we need to? What do you suggest the board do about this?
I suggest that the board look at the evidence that's presented and utilize the best evidence of record, which is our evidence. I'm certainly not suggesting that we go through another year or so of delay to have us reassemble a traffic group from more recent data and then have 3 more rounds of evidence. APCO is a modest-sized shipper. It doesn't deserve a process like that.
Thank you.
Thank you, Mr. Rosenberg. Now, counsel for BNSF and Union Pacific, please step up to the podium in the order you've agreed to. Introduce yourself for the record and state the amount of allocated time that you'll be using and begin.
Good morning. My name is Michael Rosenthal. I represent Union Pacific Railroad Company, and I plan to use about 20 minutes of the defendant's time. Mr. Sipe, who represents BNSF Railway Company, will use the remaining time. I plan to focus on the issues presented by APCO's use of a hypothetical interchange point between BN and UP. Mr. Sipe will provide BN's perspective on that issue, and he will also address the treatment of the Southwestern Railroad in jurisdictional cost calculations, and both of us will be happy to answer your questions on other issues. We think the central question in this case is whether APCO can base its standalone cost presentation on the premise that the defendants interchange their traffic somewhere other than the points that are part of the challenged rates. We think the answer is no for two reasons. First, the answer is no because the interchange point is an essential part of a joint rate, and the statute requires the board to determine the reasonableness of the actual rates that carriers establish. APCO's standalone cost presentation is premised on different interchange points than UP and BN established for the issue traffic, so the board can't determine from APCO's evidence whether the challenged rates are reasonable. Second, the answer is no because disregarding the actual participation of each defendant in the issue traffic produces a meaningless standalone cost analysis. Rather than address the costs associated with the defendant's actual responsibilities for transporting the issue traffic and the revenue available to cover those costs, APCO presumes that one defendant displaces the other for significant portions of the routes, and as a result, its standalone cost presentation does not address whether the rates for the services provided are reasonable. Let me try to explain how we get to these points. The tariff governing the New Mexico issue traffic specifically identifies the interchange point between BN and UP as Deming, New Mexico. The tariffs governing the Wyoming and Montana issue traffic identify the interchange points as Pueblo, Colorado. In the real world, BN moves the New Mexico issue traffic east to Belen, New Mexico, then south to Rincon and the Southwestern Railroad, which interchanges the traffic at Deming with UP. UP then carries the traffic to APCO's plant in Cochise.
Excellent. Doesn't the board's policies allow the complainant rather to reroute traffic to create the most efficient line, and isn't that what they've done? I mean, and a rerouting of traffic, one would presume, could cause a change in the interchange points?
Well, the board's rules allow the rerouting of traffic, but that's not just what has happened here. What's happened is the complainant, APCO, has presumed a change in the defendant's responsibilities for handling the issue traffic, and that brings with it a change in the traffic that can be part of the issue traffic group, and that causes a major distortion in the standalone cost analysis. This isn't simply a question of rerouting the issue traffic. It's a change in the defendant's responsibilities. It's a change in the rate, and it's a change in the traffic group.
Do you think the board needs to be more specific as to what we're going to call permissible reroutings and changes in creating a SAW? Or do you think the board's rules and regulations right now are fine? It's just that you feel that the complainant has abused them?
Well, I think the board's precedent is clear that rerouting is one thing, and assuming that the traffic and revenues of one carrier are available to the other carrier when in the absence of some sort of cost sharing or revenue sharing arrangement. I think the board has been clear in its precedent where the line is and what makes for a sensible cost test. This case presents the problem in a slightly different light than in prior cases, but I think the lines were drawn by the prior cases, and the precedent is out there.
Thank you. That's fine.
I was showing the routes, and I don't have to go through them, but what's happening is we've got the real world interchanges again at Deming and at Pueblo, and the reason we are where we are in this case is because APCO knows what would have happened if it had based its standalone cost presentation on the actual service provided by the defendants. We did the analysis, and APCO essentially concedes that if you had done the standalone cost analysis based on the actual routes, the board would have to dismiss the case. So essentially APCO tries to avoid the result by disregarding the challenged rates. And it's easier to see and understand what APCO has done by looking at a simplified schematic of the routes, which we've prepared. And essentially, APCO developed its standalone cost presentation as though BN and UP interchange all of the issue traffic at Vaughn, New Mexico. So for the Wyoming and Montana traffic, APCO presumed a change in the endpoint of BN's responsibility from Pueblo to Vaughn, and it used that new endpoint to justify taking BN's non-issue traffic moving south of Pueblo and using that revenue to offset what are actually UP's costs to move the traffic from Pueblo to Vaughn. And this BN non-issue traffic includes huge volumes of intermodal traffic moving over BN's Transcon line through Vaughn and Amarillo. It answers Commissioner Nottingham's question about what was so attractive about Amarillo. But this is traffic, this Transcon traffic, is traffic that in the real world shares no facilities with the issue traffic, and it's not actually available to cover UP's costs to handle the traffic south of Pueblo. You see essentially the same thing with the New Mexico route. APCO presumed a change in the endpoint of BN's responsibility for the New Mexico issue traffic to Vaughn, and it used the new endpoint to justify taking revenue from UP's non-issue traffic moving between Vaughn and Deming and using that revenue to offset what are actually BN's costs to transport the issue traffic between Berlin and Deming. And APCO tries to defend this by saying that what it's doing is it's just rerouted the issue traffic as permitted by coal rate guidelines. But as I addressed with Vice Chairman Mulvey, it didn't simply reroute the traffic. It presumed a change in BN's and UP's responsibilities for transporting the traffic, and therefore a change in the traffic and revenue that are available to offset the costs of the issue traffic. And so what you ultimately have is an APCO standalone cost presentation that's based on service the defendants don't provide. It relies on traffic and revenue that do not pay and cannot be expected to pay for the costs of the service that are actually being provided. And the result is that APCO's standalone cost analysis can't be used to address the critical issue in a standalone cost case, which is whether the issue traffic is cross-subsidizing portions of the defendant's network that it doesn't use. And this approach conflicts with the statute and with the purpose of the standalone cost test. The statute recognizes that an interchange point is an essential part of the joint rate. Section 10703 expressly recognizes that the rate established by the carriers for interline transportation is applicable to a specific through route that the carriers established, and the establishment of a through route necessarily entails the specification of an interchange point. So by presuming different interchange points than the carriers established, APCO is essentially asking the board to regulate non-existent rates. And under Section 10701, the board's rate reasonableness jurisdiction extends only to a rate established by a rail carrier. Under Section 10704A, the board may prescribe a maximum rate only after it determined that a rate charged or collected by a carrier is unreasonable. And that's not what APCO is challenging.
Mr. Rosenthal, if I could ask, you're arguing about the cross-subsidy and the importance of cross-subsidy in our analysis. Are you basically arguing that as long as there's no cross-subsidy, any rate would be valid?
Well, what we're arguing, there are different ways that tests of carriers' rates can be constructed within constrained market pricing. The test that APCO chose to proceed under in this proceeding, the standalone cost test, requires APCO to show that defendants are using its rates to cross-subsidize portions of the network that APCO isn't using. So what we're saying is that under the test that APCO chose to proceed with, they haven't proven their case.
If I could just follow up, we get different types of cases, obviously. One recent hearing we had that resulted in actually a settlement recently involved the possibility of a barge alternative. How would your analysis on the interchange argument and maintaining the existing interchange work if the shipper proposed a barge operation as an alternative to the joint line rail service?
That's a good question, and it highlights that there are really two different issues going on here, where it highlights what the key issue is in this case. And the key issue is traffic selection in a standalone cost case and traffic grouping. And one of APCO's points is the board's rules might allow a barge, the board's rules might allow a complainant to build a coal slurry pipeline. But even in that case, you'd still have the question of what traffic do you include in the traffic group? What traffic is part of this? What revenue should we include? And I mean, just to take a wild example, if it was a coal slurry pipeline, APCO wouldn't be carrying a lot of the intermodal traffic in this case that's having a major effect on the rates. So I think the issue is still there. It's still the one that we're focused on, which is which traffic is part of this case. And what we're saying is that APCO, by rerouting, can't circumvent the board's usual rule that you can't use traffic and revenues of one carrier to offset the costs of another, absent some sort of revenue sharing arrangement.
On this interchange point again, couldn't UP and BNSF simply have offered individual rates to the interchange? So from A to B is BN rate and B to C the UP rate, and basically the Rule 11 rates rather than a joint rate. And in that case, the rates could have been separately challenged, and the argument to move the interchange could not be made. Is that correct? You had the option was there to have separate rates to the interchange.
I think that's right. I mean, if you talk about how carriers could react, there are different ways of setting rates under the board's rules. Under 10701C, carriers generally have the initiative to establish any rate that's lawful, and they could have structured something different that would have, perhaps established even more firmly, although the tariffs here specify the interchange point, and the board's rules say you have to challenge from origin to destination. So I'm not sure that the practical result would have been different, but if what you're saying is the carriers could have made this even more clear.
But had you done that, they could not have moved the interchange point because the rate was to the interchange point and from the interchange point to the mine. So
I don't think they can move the interchange point in this case either. I think the board's rules are pretty clear, and the statute is pretty clear that you've got that the interchange point is part of the rate, and you've got to challenge the rate, and anything else just gets you into a manipulation of revenues and costs. And as I've said, the board has addressed in the first APCO case. It said you can't pretend that the revenues of one carrier are available to the other. It goes beyond the creativity that parties are allowed in designing their standalone cost railroads, and it distorts the SAC analysis. It doesn't tell you whether the rate that Union Pacific and BNSF established for this traffic is reasonable, and that's ultimately the purpose of this test.
Thank you.
So, yes.
Mr. Rosenthal, sorry. Just so you don't run out of time, I would be interested in what you're thinking. I assume you think, with respect to the recession, that We heard Mr. Rosenberg's piece that we assume you think that your evidence is the best evidence of record. And I did notice, assuming that we accept that we take into consideration the recession in the way you suggest, that there has been this uptick. And I'm also very aware of Mr. Rosenberg's concerns that we don't want to go through this all again. Is there any other information out there possibly that we could use to maybe take some of this into consideration?
Let me just try to go through this a little more systematically. I want to address your concerns. First, both parties recognized that there was a recession and that the traffic levels in 2009 were less than some early forecasts that were produced by the parties in discovery predicted. Both parties recognized that we were starting with a traffic base that was based primarily in 2008 with the first quarter of 2009. So both parties tried to make an adjustment. What APCO did, and I'm characterizing it, and you could try to follow it in their evidence, it's a bit difficult, but they looked at what the projections were, the sort of pre-recession projections were. Then they looked at an overall traffic result in 2009 and tried to make an assumption that if the carriers had predicted something pre-recession, you could apply essentially the same presumptions in reverse to what the traffic would have done given a recession. And what we said is, we think there's an easier way. We think you can focus on the traffic that actually moved in 2009, look at the actual lanes involved, and see how traffic changed. So we both tried to make an adjustment. APCO seems to have a misunderstanding of what the railroads tried to do. We didn't try to select a new traffic group. What we tried to look at were origin and destination pairs that had traffic moving in both periods and say what happened to the traffic. And we tried to develop an index and scale it up or scale it down. And Mr. Rosenberg says, well, we wouldn't have accounted for new traffic that wasn't in the first period but suddenly appeared in the second. And our response is, well, that's true, but we also took out of our analysis traffic that existed in the first period and completely disappeared in the second period. This isn't perfect, but what we ended up focusing on were changes in volume for lanes where there was traffic in both periods. It may not be a perfect adjustment, neither was perfect, but we think that by focusing on the traffic in the lanes rather than using pre-recession forecasts and system average traffic, we think we got a better estimate. With regard to post-2009 data, it's a separate issue. There were separate data used to project what would happen in 2009 and what would happen after 2009. After 2009, again, there were projections, there were forecasts in the record produced by the railroads. APCO chose one. I don't want to get into highly confidential information, but there were different forecasts with different predictions about the pace of economic recovery. APCO chose one. The railroads agreed with the choice, and we moved on with the case. And whether that forecast, which projected things out a number of years, not just to 2010, but I believe, well, it may be highly confidential, but for a number of years, whether that forecast will prove true or false, it's much too early to say. It's much too early to say.
So the railroads actually agreed with APCO's approach to the uptick?
The railroads produced several forecasts of what traffic would do. The forecasts were based on post-recession assumptions, when the recession would end, how quickly traffic would recover. APCO picked one. The railroads said fine. So for future projections, there was really no disagreement about the source of the data. And for the 2009, both parties recognized that there needed to be an adjustment. The question was the methodology of making the adjustment.
The basis of the assumption and the basis of the traffic growth differ. In other words, BNSF, UP's base and APCO's base from which the growth in traffic will take place differ. Is that not true?
There's a slight,
Yeah.
There's a difference in this. There were sort of two separate issues. One had One had to do with coal traffic, one had to do with non-coal traffic. For the coal traffic, what APCO actually did in rebuttal was we had criticized their use of April 2009 data, April 2009 projection. In the rebuttal, they switched to a 2010 data source that actually took into account the effects of the recession. So for coal, there's actually much less of a difference between the parties than there was at the beginning. For non-coal, it really is a different methodology of how to account for what happened in 2009. We didn't try to construct a new traffic group. We tried, like EPCO did, to index it. We just used different data indexing process.
Thank you, Mr. Rosenthal. Mr. Seib?
Good morning, Chairman Elliott, Vice Chairman Mulvey, and Commissioner Nottingham. My name is Sam Sipe. I'm here today on behalf of BNSF Railway. I have 3 points I'd like to make this morning in the 10 minutes allotted to me. First, BNSF emphatically concurs that the interchange issue that Mr. Rosenthal has addressed in some detail is the key to this case. It will determine the outcome. Some of the other issues that you've identified here this morning are important and of course should be properly resolved for purposes of not only getting it right this time, but for purposes of guiding the parties in future cases. But this interchange issue is going to determine the outcome of the SAC test in this case, because as Mr. Rosenthal noted, if you do it right and do the analysis based on the actual interchanges that the defendants used to provide the service to APCO, they don't get over the hump on the standalone cost test. This issue, to speak to Vice Chairman Mulvey's question about the clarity of the board's precedent, this issue regarding the interchange and how the board's rerouting precedent applies is an issue of first impression in this case because it's a multi-carrier case. It's because there are two defendants in the route that we need some clarification to the facts here regarding the prior precedent that talks about rerouting in the context of a single carrier case. APCO tries to downplay the interchange issue by characterizing its SAR configuration as involving an internal reroute and contending that APCO internally reroutes both the New Mexico and PRB traffic consistent with established board precedent. And yes, the board says you can do internal reroutes of issued traffic, but there's no internal reroute here with respect to the real-world service provided by each defendant. In the real world, the interchange points agreed to by the carriers define the boundaries of their responsibility for providing service. Thus, the interchange point in an interline rate case is the equivalent of an origin or destination in a single carrier case. And it's axiomatic that the standalone railroad must serve both the origin and the destination. So too, in an interline case, the design of the standalone railroad must respect the interchange point because it defines the boundary of the participating carrier's responsibility for transporting the traffic. In addition to defining their respective geographic boundaries of responsibility by their specification of an interchange point, BNSF and UP have distinct corporate boundaries. They are not responsible for paying one another's costs, and they don't have access to one another's revenues. APCO's shifting of the interchange points away from those agreed to by the carriers not only results in a meaningless cross-subsidy analysis, as Mr. Rosenthal explained, it also represents an impermissible blurring of corporate boundaries by using BNSF revenues to offset UP costs and vice versa. The board recognized in the prior APCO case that it would not be appropriate to claim a carrier's revenues to offset costs for which it is not responsible. The board should respect the carrier's specification of interchange points because doing so will respect the corporate boundaries of the two defendants. And I would note there is precedent on this issue of, if you will, the boundaries of a defendant's responsibility, and it's a little bit different subject from the rerouting. And the principle, which we've addressed in our brief, was reiterated by the board in TMPA when it said, the analysis of the reasonableness of a defendant carrier's rate should be based on the extent of the defendant carrier's participation in the movement.
Mr. Seip, if I could ask, on your point about the sanctity of the interchange points that's determined by the railroads, what can railroad customers, shippers do then if they are concerned about the routing? If they think the routing that the railroads have determined and set up disadvantage them, should they petition the board for an alternative routing, and for in this case possibly through Amarillo, and then make certain showings to have the routing determined? Because surely, I mean, railroads understandably are in the business of producing the highest value possible to their shareholders, not necessarily and always providing the lowest possible rate to their customers. I think we're all concerned that the interchange points determined by the railroads might not always be determined purely on efficiency and rail operational grounds, but could this be sheer for economic gain, and rail customers might want to petition for an alternative routing?
It's a good question, Commissioner Nottingham, and it's a question that I believe has a very straightforward answer. There is a statutory provision, Section 10705, and there is board rules, competitive access rules, implementing that statute that says if a shipper can demonstrate the railroad routing is inefficient, the shipper is entitled to have the traffic rerouted. Here in this case, if you focus, for example, on the New Mexico traffic, there's no way in the world that the board would ever find that APCO's proposed rerouting of the traffic is more efficient than the actual real world routing. APCO increases the length of haul by a very substantial amount. The variable costs of handling this traffic over APCO's proposed reroute would be far higher than they are on the actual issued traffic movement. So, we would say fine. If their problem is that we haven't given them an inefficient routing, bring it on under the competitive access rules in Section 10705.
You're basically saying there's a reasonableness standard here, and that the creation of the SAR by EPCO is unreasonable, it goes too far, and that they're sort of overcapitalizing the SAR in order to justify it, in terms of relying on it. Problem, of course, is what if it was raised before? What if it was a water carrier that was going to be part of the joint movement instead of two railroads, and that might require a different interchange point to get to where the water carrier is located? Wouldn't you be able to justify changing the interchange points in those cases?
As Mr. Rosenthal said in responding to a similar question,
yeah.
The issue here is what traffic is available to offset the costs of the standalone facility. And we think the traffic has to be the traffic associated with a defendant carrier's participation in the movement. It doesn't make sense for APCO to be claiming revenues from BNSF on those movements from Amarillo to Vaughan, for example, which have nothing to do with the New Mexico issue traffic. So how that would all play out in the hypothetical situation of a water carrier movement with a different interchange point, I can't tell you what the exact mechanism would be, Vice Chairman Mulvey, But I will say to you that it would be inappropriate to allow the complaining shipper to rely on traffic that has nothing to do with the issue traffic. And that's a sort of first principle of SAC. Grouping of SAC traffic, which is frankly what allows shippers to win the cases when they win. Grouping is supposed to involve sharing of facilities with the issue traffic, and they're not doing that here. There's one other point I'd like to make. Mr. Rosenthal mentioned that I would say something about the Southwestern Railway variable costs, and I'm going to take a pass on that unless you want to ask me about it, because we've addressed it thoroughly in the brief. But there is another point I'd like to mention to the board, and that involves the methodology for allocating revenues on crossover traffic. If I may be very brief. The board's use of modified ATC instead of original ATC to allocate revenue on crossover traffic has been remanded by the D.C. Circuit to the board in the pending Western Fuels case. In the present case, defendants argued in their reply evidence, which was submitted before the D.C. Circuit's remand, that original ATC is the proper approach to apply, and the D.C. Circuit's remand reinforced that position. Defendants submitted evidence on original ATC revenues in their electronic work papers in this case. BNSF believes that the board should refrain from addressing the proper approach to revenue allocation in this case while the issue is pending in Western Fuels. Before issuing a decision in this case, the board should determine whether the choice of revenue allocation methodology makes any difference in the results here. We don't think it will make any difference, but if you decide that it does, then we would request that the board hold this case in abeyance until it decides the revenue allocation issue in the Western Fuels case. Thank you.
Thank you, Mr. Sape. Mr. Rosenberg, you have 5 minutes on rebuttal.
Thank you. Let me address a few points in rebuttal very quickly.
And by the way, you should keep your answers to Vice Chairman Mulvey's questions short, because he has 7 pages of questions. So.
I'm aware of that. I'll do my best. First, the Railroad Council said that the answer about rerouting the traffic and using a different interchange was important, and they said that it was pretty clear. We agree that it's important. It's pretty clear. In fact, the board addressed it in APCO's prior rate case, and when the board said that APCO could reroute the New Mexico traffic through Vaughan, El Paso. What the railroads, while they claim that you should stick to precedent, they're actually asking you to jettison it, and you shouldn't. Let's see. I want to clarify my comments on the updated evidence as to volumes. When I said that APCO had the best evidence of record, I should say that APCO has the only evidence of record that you can utilize because the railroads did not submit complete data. Also, the idea of filing a motion to compel or other discovery requests when the evidence has already gone in would be problematic because discovery has already closed. The discovery is supposed to happen before the evidence comes in, not afterwards. With respect to the non-updating of projections for the recession, I think of the non-coal volumes, I think Mr. Rosenthal described it properly. But what happens is that the railroads previously had a forecast that APCO utilized that showed volumes going down and then recovering and trending upwards. What the railroads are trying to do is to lock in a greater than projected decrease and keep that intact throughout the remainder of the DCF period, so the volumes are always below the projections. Our point is that with the recovery so far, with the data that's available, it shows that the original projections are reasonable, if not conservative. It's also been indicated that or or implied that the UP's Vaughan El Paso traffic shares no facilities with the traffic moving to moving to APCO. In fact, with our standalone railroad, 85.7% of the traffic that we depict as moving over the Vaughan El Paso segment actually moves west on UP past Cochise to points further west. So it is traffic that is logically and reasonably available. With that, I'd be glad to respond to as many of the pages that Vice Chairman Mulvey has as I can in the time available.
I think in the interest of time, I would ask the chairman to keep the record open as you usually do, and we'll submit some of these questions to be responded to for the record to both the APCO and the two railroads.
Mr. Chairman, if I could, Mr. Rosenberg, I'm trying to figure out a way to harmonize Section 10705 regarding competitive access with the standalone rail cost model. Do you believe that shippers should make some type of efficiency argument or showing if they're going to adjust interchange points and reroute traffic in their SAR, or does efficiency have absolutely nothing to do with the standalone railroad model?
What APCO did is APCO filed a rate case. What we're saying is that the rate is too high, that we pay too much, that we end up cross-subsidizing other traffic and enriching the carriers excessively. That's what the standalone cost analysis does. That's what we demonstrated. The board's earlier reasoning is that if the railroads have the capability to adopt a different routing, then the standalone railroad has that same routing, has that same flexibility, and applies it in the standalone world. And that's exactly what we did. Frankly, we think that the railroad position is a little bit contrived. And if I can belabor an example, suppose with the New Mexico traffic that we had filed a 10705 case, and we're saying that the way that the traffic should be handled is that BNSF should take it and handle it as far as it can go, which would be to handle it going first to Vaughan and then to El Paso using the trackage rights that we tried to use in the earlier case and were not allowed to use. And then at El Paso it'd be handed off to UP. That's consistent with the preference that's given the originating carrier. Even if we had done that, we would not be able to, based upon the earlier rate case, to use the trackage rights. What the railroads are trying to do is to make it more difficult to bring a rate case where there is a joint line or joint through rate movement involved. That's inconsistent with APCO's prior rate case. It's inconsistent with the coal rate guidelines. It's also inconsistent with the Staggers Act conference report, where it says the same rate standard for other rates should apply to joint line rates. It's unnecessary.
If I could try to get you to answer the question a little more precisely, so how should efficiency play into our consideration of a case like this? Does it have absolutely no bearing whatsoever on the case, or should we be keeping some sense of the efficient operation of the national interstate rail system in mind as we try to reach an equitable outcome in this case?
I think efficiency is being used in two different senses, and it's the nature of the analysis. It's one thing when you're looking at the world as it currently stands, what the railroad's legacy, what they've inherited. If you're looking at the railroads as they stand today, you have the line that runs from Berlin to Deming. It's logical for the railroads to use it. In the standalone world, you start with a clean sheet of paper where you need to recoup all of your investments. A different routing makes sense. The railroads get to have the higher of the standalone cost or the jurisdictional threshold. That protects them more than adequately under these circumstances.
So did I hear you say that in the real world, efficiency, of course, should matter, but in a case such as this, it should not matter?
No, I'm saying that efficiency is applied differently in the two contexts, and the railroads are the beneficiary of having the rate determined as the higher of the jurisdictional threshold or the standalone cost. In this case, our standalone cost analysis shows that the railroads at the jurisdictional threshold receive more than they need to be able to handle the traffic. Yet the rate is going to be set at the jurisdictional threshold instead. That's a cross subsidy. It's what the statute as applied by the board calls for. That's and that's sufficient under these circumstances.
Mr. Rosenberg, just one follow-up regarding changing topics a little bit regarding EPCO's hypothetical railroad operating plan. If I understand the hypothetical railroad proposed, it would be about 3,310 track miles. It would carry a substantial amount of intermodal and general freight traffic, but it would have no classification yards nor intermediate switching anywhere on its system. That sounds remarkable to me. Is that a fair characterization of the hypothetical railroad you're proposing?
APCO's traffic group consists of unit coal trains, and it consists of overhead traffic plus a limited number of intermodal trains that it originates at El Paso. That's traffic that the defendants handle, and that's the traffic that APCO has included proceeding on a least cost, most efficient basis, which is what the coal rate guidelines contemplate. To require APCO SAR to engage in other activities is to force APCO to pay for other traffic, to construct facilities that are not needed to handle its traffic or the other traffic that it's selected for its traffic group.
But in the real world of railroading, a 3,310 track mile system carrying a great diversity of traffic would in fact have intermediate switching at multiple locations, it would seem to me, and would probably have classification yard facilities as well. And those things cost money, and how do you account for that in your hypothetical railroad?
The hypothetical railroad does not need those facilities in order to be able to handle APCO's traffic. To force APCO and the other shippers to pay for those facilities that they don't need constitutes a cross subsidy. It constitutes an inefficiency that's inconsistent with the coal rate guidelines, contestable market theory, and standalone costing.
This case, this hearing is sort of a good example of no good deed goes unpunished. The board over the last few years has made a lot of efforts to try and simplify the whole rate case process, including opening up processes to small shipments. But obviously, we still have very, very complex cases, and this particular case is especially complex. I wanted to ask a question about some of the board's changes. We've adopted the average total cost approach and the maximum markup methodology recently. And I was wondering to what extent those changes in our processes affected APCO's approach to building its traffic group and its operating plans, and if those changes had an effect, what was the effect of in constructing the traffic group and operating plans? The maximum market methodology and the average total cost approach. Or is that a question better submitted for the record? You consult with
it's probably better submitted for the record, but if I can venture, it made it more complicated. But on the other surprise. Let's see. Originally, when we submitted our opening evidence, we had to run it on the beta version of Office 10 because the spreadsheets were just too large to run otherwise. So so this is a good sized standalone railroad. It makes it more complicated. I would have to check with our consultants as to whether or not we would have done anything differently as a consequence. One of the things is that in trying to put a rate case together, a lot of the stuff comes together at the end because everything cannot be fully contemplated in advance, particularly with the demands of the RTC analysis. So you anticipate, the board sets up rules and we try to work with it. And in this case, we believe that we have.
Thank you.
Thank you, Mr. Rosenberg. Thank you, counsel, very much for appearing today and for your excellent arguments. And we'll take the matter under advisement. And the meeting of the board is now adjourned.